I'm struck by the fact that Section 230 has enabled some platforms to grow enormously large. Facebook, for example, is worth $500 billion or more, depending on the day of the week, and it would not exist without Section 230. At the same time, there have been stark incidents with Facebook being able to use Section 230 to hide from the consequences of its actions. For me, the most obvious and the most egregious was that by its own admission, Facebook's platform was abused to catalyze the Rohingya genocide, which left 25,000 people dead and a million people as refugees. Those are real world consequences and those are real world suffering. And as much as no one at Facebook committed those crimes, the scale of those crimes would not have been possible without Facebook as a platform and without Facebook's inattention to how its platform was being used. I suppose my question for you then is, I'm convinced by your argument that Section 230 plays a valuable role in society at large, and I'm convinced by your argument that the Supreme Court is an excessively blunt and unnuanced instrument to bring about any necessary changes. But within that context, what changes should there be? Should there not be some means of balancing the enormous power that have accrued to some platforms with a proportionate level of accountability? I can't think of any other corporation or organization that could precipitate the deaths of 25,000 people and be able to say, this is not our business. In the end, irrespective of how this case goes, how would you like to see the regulatory architecture over social media change so that we can have the sorts of freedoms that have given us a global town square without at the same time the kinds of jaw-dropping abuses that we've seen in places like Myanmar?
I will I will say one thing here is that we haven't talked a lot about, although I think there was a very quick mention of it at the start of the call, which is the antitrust laws. Um, and I don't want to go too far on this issue. Also, I will just note here I'm speaking for myself. This is not a position of the Wikimedia Foundation. Um, but I think that looking at the antitrust laws is one of the things that should be considered in this context, because a lot of the question is seems to be right now focused on the consequences of like this harm happened and this other harm happened, and how do we make it so that we regulate it so people won't do those harms. But a lot of those harms come back to this question of size and power. Um, and that is what antitrust was built to combat. To say, like, maybe it's bad for society if there are a very small number of very large, powerful organizations that are controlling everything. Maybe there will be harms that we can't predict that they will cause. And it would be better if things were a little bit more spread out, if there were more competition, if there were more companies doing things in a greater variety of ways, and that will lead to a better society. Antitrust for a very long time in the United States in particular got really caught up with just the question of consumer prices. Like, was something making your bottom line, like your pocketbook, thinner because you had to pay a higher price? And if not, then there was obviously no harm and no need for antitrust law to get involved. Um, but I think what we're seeing is that there are these like really significant harms that can happen, and that may be in part due to the like size and scale and organization of some a small number of very large companies, frankly. And I think looking at how the antitrust laws can be used there is an important aspect of it. And so that would be one area that I would look at in thinking about how to address this.
That's an interesting argument that it's not the new technology, it's the old evil of concentrations of power.
Yeah, and the other
Ben,
angle, sorry, Akash. I think the other angle I would kind of add to Jacob, with the standard caveat, of course, that at this point I'm talking about my own personal opinions and how I would see the universe is. You know, the other angle to this, of course, is what we're talking about is the international law aspects of this. I mean, what we've been focused on is the regulatory structure in the U.S. and in the EU, but we haven't talked about, you know, when we're talking about market power in Myanmar of Facebook, for example, these are very, very, very tough. Um, in other words, the amount of power Facebook has in one jurisdiction versus another, it varies quite a bit. And in certain jurisdictions, they are the default go-to for purposes of their basic communication channel. And that's where some of these issues kind of, in some sense, blow up and become even more severe. In some ways, the DSA is one response. I would say I still have yet to be sold that it is, that risk assessments and the nature of how to kind of organize them and use them to, in essence, say, hey, as a platform, you're going to be held to account for not having taken account of the harms that were reflected in the risk assessment is one mechanism. There are other mechanisms that I think like we need to explore, including the competitive pieces that, especially when these platforms become such a key piece of how people communicate, how people interact within a particular society and a jurisdiction.